My name is Melissa Gragg, and I'm a divorce valuation expert in St. Louis, Missouri. I work with business owners and entrepreneurs in every stage of the divorce process, whether in mediation or litigation. There are so many questions and myths about what happens in a divorce when you own a business. So here are some of the top valuation issues every business owner should know before you file for divorce. So now, we have the business covered, but then the entrepreneur is now concerned about the other assets or investment accounts. They might wonder, how do I protect all the other investments I owned before I got married? Well, there are a couple ways that you can protect your assets or investments that you owned prior to when you got married, but most of the ways involve some planning prior to marriage. So there are prenuptial agreements that are one way to clearly establish how things get separated if you get divorced. Many times people will not necessarily want to do these at the beginning or before the marriage. So a postnuptial agreement is done during the marriage. The thing with postnups and prenups is they don't always hold up in court, but both parties try to agree to some of the stipulations of what could happen if you get divorced. Many times I've seen some of the best planning done by very wealthy families who want to protect the wealth for each generation and want to preserve it from getting dissipated or lowered in a divorce. For example, there was one case where the house that the couple lived in was really owned by the wife's parents' estate and held in a trust that would not transfer until the parents died. So the couple was living in this beautiful mansion, and after the couple filed for divorce, the husband thought that the wife would keep the business and the husband would take the house, since they were worth roughly the same amount. The problem was the couple really didn't own the house. Now, there are always other issues when money to buy a house was gifted to another couple, but after the divorce, the checks were clearly gifted to the wife only, and therefore there was a portion of the house that was separate and a portion that was marital. Not as easy to figure out, right? But you just need to keep some clear records of any gifts or inheritances because these are typically separate property. One of the ways is to keep track of what you had prior to the marriage, meaning keep the investment account statements and do not commingle your accounts. So if you have an investment account with $100,000 prior to the marriage, set up arrangements with the financial institution that any income or dividends will not be reinvested in that same account, but actually be put into another account that is a joint marital account. Because remember, the income could be marital, but at a minimum, the accounts would be easier to trace back to the time of marriage. This is just one way to prevent the accounts from being commingled or mixed together and considered transmuted or converted from separate to marital. And realistically, if the valuation expert you're working with doesn't understand these concepts of commingling or transmutation of property surrounding marital and separate accounts in your state, and this is an issue in your situation, you really might want to consider contacting some other people who have dealt with these issues. So now, I'm considering filing for divorce, but I want to be prepared. What should I do next? Give us a call. No, really. You should reach out to somebody who specializes in valuations for the purpose of divorce. There may be valuation companies near you, but do they understand the divorce court system in your state? That would be a good first question to ask. Then see how many times they've testified. Are they trained as a mediator? Do they understand how to negotiate these settlements with other experts? Well, if you have any additional questions or you want to talk about your specific situation, give us a call at 314-541-8163 or check out our website at valuationstlouis.com.